Welcome to the Property Management Mastermind Show with your host, Brad Larson. Brad owns one of the fastest growing property management companies in San Antonio, Texas. This podcast is for property managers by property managers. You'll hear from industry-leading professionals on best practices, new ideas, success stories, and lessons learned. This is your opportunity to learn about the latest industry buzz surrounding property management, as well as tips and strategies to improve your business. Now here's your host, Brad Larson.
This episode of the Property Management Mastermind Show is sponsored by Lead Simple and 4.5. They have teamed up to come up with one of the best conferences for anyone in or around the property management industry to attend. It's called the PM Grow Summit. This conference is laser focused on growth strategies and thought leaders from around the country. Now, I personally attended their PM Grow Summit last year and was truly impressed with the format, the venue, the quality speakers, and the level of attendance. And that was just their first year putting it on. This year's PM Grow Summit will be held in San Diego in early 2018, and it's shaping up to look like another fantastic event you will not want to miss. I've already booked my spot for the conference and I will encourage listeners to do the same. You can learn more by going to pmgrowsummit.com. As an additional incentive, you can enter in the promo code BRAD, B-R-A-D, to get a $100 discount when booking your ticket. If you ever need an excuse to go to San Diego and stay at one of the historic downtown hotels, this is your chance. Do not miss this event. Again, go to pmgrowsummit.com and enter in the promo code BRAD for a $100 discount on admission. Hey everybody, and thanks for joining us. In today's episode, I talked to Robert Brown, and a couple things I wanted to make sure you understand. Consider this a disclaimer because Robert Brown is a local San Antonio attorney licensed here in Texas. Any of the discussions, topics, issues that we go through here should not be considered legal advice. So I'm just throwing that out there now as we kind of forgot to mention that, but a little bit goes without saying, but I just want to make sure that everybody has that disclaimer out there. And also I wanted to ensure that everybody kind of got this as one of the topics that we talk about is assistance animals. And one of the things we forgot to mention was assistance animals covers all the terms of ESAs and service animals and emotional animals and anything inside of there. So we probably should get on the same page and call them assistance animals directly. So this is a pretty good listen. You're going to learn quite a bit about fair housing and service animals, assistance animals. So take a listen and see what you think. And welcome to another edition of the Property Management Mastermind Show. Today's guest, I have Robert Brown. He's a local San Antonio attorney, and Robert and I have been working together for quite some time. And I wanted him to come on the show today because we want to talk about fair housing, and we also want to talk about service animals. And as all of my peers have talked about, we don't know what to do at this point. So Robert, I got to introduce you. Tell us who you are, what you're doing, give us some of your background. And let's get into this because we got lots of questions to go over.
Well, my name is Robert Brown. I have my own practice here in San Antonio, and I'm a real estate attorney. And I specialize in representing landlords, both in the residential property management context, also in the multifamily, as well as commercial landlord tenant matters as well. And one of my subspecialties is fair housing and all things related to dealing with request for reasonable accommodation, request for reasonable modification, anything related to that.
Kind of all of the above.
Yeah.
And to let everybody know out there, you are the subject matter expert, in my opinion, in this region, especially in we're dealing with the fair housing, dealing with service animals. You're our go-to guy. You've been trained under some of the best in the San Antonio region, and now you've been practicing on your own. And we use you in a lot of different ways. We've got notices to vacate we got going through, collection letters. And then anytime we have a fair housing issue or service animal issue, we're coming to you for advice. And more San Antonio property management companies are coming to you as well. And I would expand that to even Austin or Dallas. Eventually, they'll start coming to you because you seem to be the resident expert. And there's a niche there for sure for an attorney to do this. So let's start off right away and going through some of the tough questions. Define a service animal. This is where HUD, before we can get to that, I'm stealing your thunder just right off the bat. We had a representative from HUD go to the NARPM conference a few years ago, and everybody that's watching or listening from NARPM, they remember that potentially at the broker owner conference where we could not get a straight answer even from the HUD directors themselves. I mean, we're talking the high-end guys that are the leaders of HUD. We asked them, what is a service animal? And it was so gray, it just irritated the heck of us. So let's just kind of kick in. I got a list of questions for you. Talk about the current state of concern for service animals, emotional support animals. How did we get to this point?
Sure. Well, let's clarify first. Service animals are an ADA term. Okay, so there's two things. There's the ADA, the Americans with Disabilities Act, and then there's the fair housing, the federal and state fair housing laws. And those two need to be separated. So when you talk about, people all say service dogs. Well, service dogs are under the ADA Act, and those are limited to dogs and miniature horses in certain contexts.
Miniature horses. I know.
Right.
Yeah. They work well in apartments.
Right. And those are a service animal has been trained to do a specific set of tasks. And those are for place of public accommodation. So typically in property management, your housing area that you're providing housing for is not public accommodation, unless you have an on-site leasing office, or maybe in your corporate office, like here is a potential place of public accommodation. So what we're going to talk about is fair housing. And under fair housing, we don't use the term service animal. We use the term, typically what we're seeing is emotional support animals, or a request for reasonable accommodation to have an animal to do some sort of, to assist the tenant in a certain way. And it's not a service animal per se under the ADA.
So let's back up here, because that's actually kind of important. So the correct term that we should be using is emotional support animal.
Well, it depends. Okay. I think what we're gonna go into, most people requesting emotional support animals.
That's the other part, is the reasonable accommodation. Is that the other part?
Yes.
Okay, so we call it basically service animals, and that's what everybody in the industry is going to call that. Is that still the kind of the correct term to even use?
I mean, you can call it that, but under the Fair Housing Act, they're basically requesting and I can just define, let me define this. I have my notes here so I can actually read the definition. But what we're getting to under the Fair Housing Act is they're going to request one of two things, typically: a request for reasonable accommodation or a request for reasonable modification. So what you typically are going to see is the accommodation. So that's a change in your exception to your policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling or common space. And that would be, hey, I want you to change your policy of not allowing this type of animal or this breed of animal, or I need more than one animal. And essentially it comes down to, I don't want to pay my pet fees a lot of times.
Oh, I see.
And so when you talk about a service animal, for us technical nerds, that brings in ADA. Hey, I'm going into a restaurant. I need my service dog because they perform a function. They help me see, or they help me know that I'm going to have a seizure or something. And I need to bring that into the restaurant and have this animal with me. That's a service animal. But under the fair housing, it could be a service animal. It could be one of those, but it could also be an animal that performs a different function, such as emotional support.
Clear as mud, man.
Right.
That's exactly what HUD wants, right?
Okay. That's right.
No, I think we're kind of getting the gist of what you're talking about. It's good to actually establish the technical terms, because in property management, in real estate, everything is down to what is in writing. So we always want to go to the four-corner rule, right? A lot of attorneys will refer to that as you have to go back to what's contractually written between two parties, or the standards and guidelines that are set before any sort of leasing activities taking place. So I think we sort of got that point. What are you typically seeing out there for some of the scams from potential tenants? The good ones, the bad ones? What are you seeing out there now, and how do we defend ourselves against that type of stuff?
Okay. Well, I think this stems from America's crazy love that we have for our pets, and them wanting to avoid the pet fees. Because if you think about it, if a manager, apartment management company, or a single family management company is charging $300 for a pet fee, to a deposit, or maybe even a fee, and then $25 a month per pet, that can be a lot of money, especially if we're talking a couple of years. So they want to avoid that. They want to avoid your breed restrictions. They want to have the pit bull, or they want to have the 110-pound Great Dane, or they want to have more pets. So the scams that we see are stemming from that. Hey, I can go online, I can pay for some certificate and some vest to put on my dog, and then I can avoid, it may cost me $100, $150, but I can avoid all these fees, right? And that's kind of the scam, I guess, that we're mostly seeing. And that's where we need to put up the wall and say, no, we're not doing that, because that subjects you to liability damages to the unit, potential liability to the owner if you're mismanaging their property by just letting someone have some pet in there or some animal in there that shouldn't be in there, and against their requests, and ultimately potential liability to other residents in the vicinity if you have more than one unit.
And it goes straight into the question of how do we determine that? So what we want to figure out now is, how do we know what is good, what is bad, what is legit, what is not? Kind of give us your 2 cents there, because A lot of us would think the common sense rule kicks in if they bring you some BS certificate that they just printed up online from Dr. Zhivago in, Austria. Well, okay, that's a little hokey.
Right.
And you've mentioned to us that we're allowed to push back. Am I correct?
Right. So in looking at how we're going to push back, let's clarify the definition of disability. And I'm just going to say it's really broad. So it's individuals with a physical or mental impairment that substantially limits one or more major life activities. And then it goes on, individuals who are regarded as having such impairment. So I read that to mean they don't necessarily have to have that impairment, but if other people think that they have that, maybe they're disabled.
And we're not allowed to really ask them why they have a service animal. Am I correct?
We can get there. Yeah, we'll get there.
Okay, I'm
sorry. And then the third part is individuals with a record of such impairment. So in their past, maybe they had a record of having this disability, PTSD or what have you. Maybe they technically don't now, but they've had a record of it. So potentially they're disabled under the fair housing laws. And so when you are triaging a fair housing complaint, there's a 3-pronged test that we use. And I'm trying not to get too lawyerly and nerdy here, but the first question is a disability apparent. This is the first thing we need to look at. Is it apparent? So if a guy comes in and he's in a wheelchair, you and I both know apparent disability. He's in a wheelchair, or he has to use something to help him walk, like a walker or a cane, or maybe he's blind, right?
Or missing a leg or something just obvious.
So it's obvious.
Yeah.
So is a disability apparent? If it's apparent, and then they've satisfied that prong, right? If it's not apparent, so I come in and say, I need Bruno the pit bull. Here's my certificate. And you look at me and say, well, I don't see anything. Well, maybe you see something wrong with me. I don't know.
No, I know what you're going
But
though.
he looks like, he can function normally. So then at that point, you can ask for substantiation of the disability.
Okay.
That's the point where you go back and say, I need a note from a doctor or and actually it doesn't have to be a healthcare provider. It can be a third party with knowledge. So what's it? A reliable third party. So it could be a caseworker. Can it be their Uncle Ted, who is a veterinarian? Probably not, because he doesn't. But it needs to be someone. So it could be a caseworker. It doesn't have to be a doctor. It doesn't have to be a nurse necessarily. So then you get that note from me or substantiation. I come in and say, here's I was in the military, and here's my doctor note from BAMC saying that I have PTSD. I served in Afghanistan.
Yeah.
Okay, great. You've satisfied that disability. Let's go to the next step. Is there identifiable relationship or nexus between what I'm requesting and my disability? So if I need a pit bull to fetch my remote, but I'm saying I have PTSD, there's no relationship there. They don't correlate. Okay. But if I need this little fluffy Bichon dog to calm me down when I'm starting to feel upset, and I grab my dog and I pet it and I feel better, then there's the nexus. Okay. So a lot of times people are missing that nexus.
I see.
As well. So they may be disabled, but just because you're disabled doesn't mean you get to have what you want. It means they have to.
Missing on both sides, because they could walk in and we're missing it because we can't see anything wrong with them. And then they're missing that because there is nothing really wrong with them to correlate with that particular animal concern.
Right.
Just like what you said. So you're not going to have a fluffy dog for a guy getting for the dog to go get a remote, that weighs 10 pounds and you got a fluffy dog. So I see where you're going there. There's got to be a need, kind of.
It has to relate.
Okay.
So, and then the third prong of that, if the request, is it reasonable? Because it's a reasonable request. Sorry, I keep doing the quote things. Is it reasonable? Because it's a request for reasonable accommodation, reasonable modification, or does it impose an undue financial or administrative burden or fundamentally alter your operations?
Oh, so that's a tough one.
Right. So there was a case, a colleague up in Austin had a case he was dealing with where the person had some sort of disability some sort of anxiety related disability. And they got a doctor's note, I guess, that said that watching chickens grazing in the yard relieve their anxiety.
Shut, really? Oh, man.
So they let him have like 3 or 4 chickens, but they wanted 6. And so after 3 or 4, they said no more chickens. And so they, brought a case saying I need 6 chickens. And then at some point it becomes an undue burden because you're pretty much turning your rental into a farm, right? Or for example, there's a case, the director of HUD, Gary Sweeney, great guy. In fact, I'll I call him once in a while and bounce questions off him if I get a strange one.
That's why you're here, man.
That's right.
Because you got the director of HUD at your
that's
speed
right.
dial.
Well, yeah, he's in the Dallas Fort Worth office. Great guy. He speaks a lot to the TAA functions and such. Gary's
TAA is Texas Association of Apartments.
Apartment Association.
Texas Apartment Association. Sorry, I had that backwards.
So Gary in his speeches will tell about a lady who was blind. She was legally blind, but she could still work. She worked at Walmart, and it was a mile or two down the road, and she needed a horse. She actually rode a horse to work. Perfect setup. The apartment is nearby where she works. She can't drive, but she can ride a horse. So she brings a note in or tells the manager she needs to have a horse. And so the manager just, okay, great, rubber stamps it. She brings a full-size horse and stables it in the second bedroom of her apartment.
Wow.
So that would be an undue financial administrative burden. By the end of this thing, when the dust finally settled, they had to go in and like hazmat gut the unit because it was just a stench. And you can imagine having a horse in a one bedroom or a two bedroom apartment. So anyway, so we can't have such an administrative burden that it's going to, fundamentally alter your operations.
Great story. Scary, but great.
Oh, by the way, one thing to add to that, if they don't satisfy those prongs, then the HUD guidance says you need to open a dialogue to see if there's a better alternative to satisfy that.
Okay, so the dialogue could be just a conversation, or would you do that in writing somehow?
I would recommend sending them something in writing, and you can also speak to them over the phone or whatever is a good way to do it with that resident. You don't want to just say you have to communicate with me in writing, because requests for reasonable accommodation you can't force them to put it in writing. It can be made orally by the tenant, or it can be made, or the applicant, or it can be made by a friend of theirs or a fair housing advocate. It doesn't even have to be by that person. So you open that dialogue. For example, if someone says, I can't reach the dumpster outside of my unit, I'm in a wheelchair, I can't reach it, I need you to build me a ramp to get up and put that trash into the dumpster. You say, well, that's going to fundamentally alter operations, the trucks coming out. But what we can do is we can have maintenance staff come by twice a week and pick the trash up outside your front door if you leave it out on Tuesdays and Saturdays. And that would be a situation where you've opened a dialogue and you've accommodated them in a reasonable manner.
I see. So that would keep you out of trouble, just to try and make some sort of win-win for them.
Absolutely.
Okay.
And that's what HUD wants.
Now, is there any best way to potentially push back? Because we talked about, the person that walks in who looks perfectly healthy and they request a service animal of a pit bull. And I'm speaking like for other property managers who see a lot of this all the time. Of course, they try to hide the name of the pit bull. You know all those tricks. I'm sure a lot of the other folks do out there too. But at what point do we say, and how do we say it, we need to push back on this? I mean, we don't say we're pushing back on this. We say, can you provide us something? And please help me there.
Right. Okay. Here's the way I recommend happening. Never respond on the spot. Have the person, your frontline person, take the request. So I come in and say, hey, I want my dog Fluffy. You don't know that Fluffy's an 80-pound pit bull, but I want to have Fluffy with no fees because I have a disability. And that person at that point says, okay, let me take your information. I don't have an answer to that right now because I need to give that to my supervisor, who's going to be, and we'll get back to you very shortly with that. And I say the right timing of that is no later than 7 days. I always try to tell clients to get back within 3 days if possible, but say, I'll get back to you on this, but I need to find the answer out because I don't know that answer.
Okay, so those individual property management company owners out there who might get a little nervous, would this be an opportunity for them to kind of hit pause with that particular applicant, go find their local attorney, and maybe get some recourse there?
Right. Okay. Write it down, write every detail you can get, ask them questions about what they're looking for and what they want. And then I would tell them, in your situation, maybe go to you as the owner of the company. And then at that point, you take a look at it. Maybe you have the expertise or feel comfortable with it, and then you give them the answer. Or maybe you're a district manager in a multifamily community and you feel like you've dealt with this enough, you know how to deal with it. Or at that point, you decide, I'm going to call so-and-so, I'm going to call Robert Brown or whoever, and you're going to give it to the attorney and say, for me, it's usually 10 to 15 minutes of work. It's pretty easy. I get the request. I've seen a lot of these. I know what to say. I send you back a cookie cutter response that says, thank you so-and-so for your request for reasonable accommodation for your pit bull Bruno or Fluffy or whoever. We strive to comply with fair housing law, federal and state fair housing laws. In order to properly complete your request, we need the following information. And then if it's not apparent, we say we need some substantiation from the medical provider as to your disability. And then if so, we need to understand the nexus of relationship. And I kind of put out the 3-step test, give it back to them in writing. You can call them and tell them as well, but I always say email it, send them a copy in the mail.
Okay.
And then the ball's in their court. And then they can come back to you. Sometimes they might just fade away, but a lot of times they will come back with a note. And then they come back with a note, and then you look at it and say, well, gee, it says they have PTSD, but they need something else that doesn't make sense for what their disability is, right?
What they need.
Then you can come back to me and I say, okay, look at this. And then we send, thank you for providing this information. However, we need this. And you can go back and forth. As long as you're staying in open communication and getting back to them quickly, it's going to help your case. The problem is when they submit a request and it just sits there a week, 2-3 weeks, then you're in the red zone.
Now, what are we talking about with pets that we have to kind of consider? Because you mentioned horses, you mentioned dogs, but what if they bring in a python, a big old long snake, and they say, this is my pet snake, Fluffy, and I want you to approve him as my emotional support animal. Here's my documentation from my doctor in Venezuela.
Okay, so in that situation, HUD doesn't say, the law doesn't say what kind of animal or not. That's the maddening part. The 3-pronged test.
Yeah, that's where all the PMs out there are like screaming at the radio right now saying, give us something that we can put out. And that's a frustrating deal. So I interrupted you. I'm sorry.
But no, we look at the snake and say, okay, now is that reasonable? Is this a 12-foot python that's going to potentially get out and strangle someone in the community, a neighbor? So
by the term reasonable, it's really kind of potentially up to the property manager, apartment community to determine what's reasonable. You don't know.
To try.
It's a try. It's a gray thing, right?
What would happen is you would call me and I would say, Brad, are we talking about a 2-foot snake or are we talking about a 10-foot snake? What are we talking about? We'd go through this analysis and I would say, at the end of the day, you've got liability to your owner. If this thing gets loose, you've got liability to neighbors. If you're in a fourplex, you've got liability to other tenants. And I don't think it's reasonable to have a 12-foot snake. And we may deny it.
Okay.
And then at that point, you're going to have to be ready because their next step is they're going to go file a complaint with HUD.
Yeah. And even if you try to give their application feedback or try to find them another place to live, they may still go do that. Is there any animal that just sits right on the fence of that? Like a cat, for example? I mean, is that to the point where it could be an emotional support animal because you can pet Fluffy, the cat, and feel better?
I would say cats probably are one of the better emotional support animals. I mean, they kind of...
Do they have a
sit
class
in your lap and whatever? But it could be a potbelly pig. It could be chicken.
Yeah.
We got to start looking at once it gets into the livestock category, then I think that's not reasonable.
Yeah. And a lot of these answers we're getting from you are gray because the rules are gray.
Right. A cougar, no, we're not going to let you have a cougar in your apartment. But yeah, so it's the problem that property managers are facing is there's no black or white.
And that's people have to understand that you're not going to be on the show now telling them how to do their business or telling them how to run things. Your role, especially working for us, is to keep us out of trouble. And so by some of the very PC down the middle answers you're giving me, that's essentially built to keep us out of trouble because it's not always a hard and fast rule. If it's a cat under 10 pounds with long hair, you can deny it. HUD does not give us that.
No.
That's the frustrating part, I guess, a little bit. But there is no perfect solution for what is a service animal, what is not, because the people that need service animals, they're always going to vary. So I understand it from both sides. Just we like things black and white. We like things cut and dry, and we get in the middle, and it drives some of us nuts.
It honestly, truly is a case-by-case basis, depending on the person, the disability, the place where they're going to live, there's so many factors that it's impossible to give a...
Let's talk numbers. How many are we forced to accept potentially?
Whatever's reasonable, right?
Yeah.
So
one dog potentially could be a reasonable accommodation, but then they need a chicken that accompanies the dog as a pet to the dog.
Yeah, it gets out of control. I've seen someone request 2 or 3 pit bulls for emotional support animal, and I pushed back. And ultimately, they decided to just finish their lease term as a month or 2 away and move out.
Yeah.
And
remember the old Seabiscuit movie where Seabiscuit had emotional support animals that traveled with him? You ever see that movie? Well, he had like a horse buddy and then like a dog buddy, and those two would travel with him on his route to get the triple cup or whatever it was, Seabiscuit. But that's what tenants will come in and say, well, this is, the chicken that supports my dog. And so I need both of them. And so I cut you off because you were talking about, kind of how do we do that? This is a reasonable request or not. And we have to determine all that stuff. That's where we would love to see more cut and dry, black and white. You can allow one and two is crossing the line. But you're saying
Well, I would push back on any more than one ESA, most support animal.
Okay.
Unless you have two tenants and they each have one potentially, but I would push back on that.
Okay.
But then at the end of the day, it becomes an adjustment call. Okay, if someone's asking for 2 Chihuahuas, do you just want to grant it? Or do you want to say, no, you can only have one, and then know that they might turn around and file a fair housing claim and you got to pay money to defend that? So
that's true. It's always a business decision, and people need to understand that because they're listening to this right now, and unless they have done this before in person, we see people on our listserv through NARPM, and they always win lawsuits. It's amazing. They just do whatever they want with no fear of being sued ever, and it just I don't know. Sometimes you just have to shake your head at that because we know how quickly this can turn into a very ugly situation. Paying for your time to defend me is expensive. And next thing you know, you could either, let's take a parallel. So let's approve that second Chihuahua, and that costs the homeowner and the management company and the residents that live around that particular tenant, it costs them practically nothing because it's just a 6-pound dog and another 6-pound dog. The flip side is if you deny that and they go file a claim, how much is it to respond? $1,000, $2,000, $10,000 to get into a legal battle over some 6-pound Chihuahua? That's the business decision that I'm trying to illustrate. And most people, you would probably tell me, Brad, just give it up and approve the dog. Don't be stupid about this.
It depends also the dynamics, who the owner is, whether you own the property or not, if it's third party, if it's fee managed or not. There's different dynamics as well that play into that. And maybe we should talk about, when you're talking about cost of defense and such, the steps how this all plays out. Because a lot of people don't have clarity on what does it mean to have a claim filed against you?
Yeah, let's go there.
So the first step typically is that they go to, the tenant will, a lot of times they'll go to a fair housing advocate like the Fair Housing Council of Greater San Antonio. And they'll go and say, hey, I'm being discriminated against. Can you help me? And a lot of times they'll lead them to file and help them, or the tenant will do it themselves without an organization helping them, but they'll go to either HUD or TWC, the Texas Workforce Commission, Human Rights Division, and they'll file a complaint. Say, I've been discriminated against. That's free for them. It doesn't cost them any money that I know of.
Okay.
Yeah, not even $5
Jeez.
that I know of.
Okay.
They'll file a complaint. And then if it's filed with HUD, HUD will either investigate it themselves or they can kick it to a state agency when the state has substantially similar state laws, in which Texas Fair Housing Act is substantially similar to the Federal Fair Housing Act. So then a lot of times HUD will kick it to TWC. Sometimes if you're down in Corpus, they'll kick it to the City of Corpus Christi Fair Housing Division. I forget the name. But then that agency will investigate. So a lot of times our investigators in San Antonio are coming down from Austin. And so they do the investigation. And then as we work through that investigation, most of the time we're able to get a finding of no cause and the case is closed.
Okay.
If the case seems like it's going south, if I see some hickeys and say, you know what, your PM did something they didn't mean to, but they shouldn't have done that. You have some liability. You can conciliate it and try to reach a settlement at that point. If you refuse to settle it and you lose, then HUD or TWC can issue a charge of discrimination, which I have. We were discussing this earlier.
Yeah, get that away from me. It looks like an official legal document.
They can issue a charge of discrimination, and then the tenant can take that charge and go to federal court and file a federal court lawsuit.
That just sounds expensive.
Here's the kicker. Even if you win, such as I've successfully defended someone on a TWC complaint, no cause, tenant was the applicant had no cause, according to HUD and TWC. The tenant still found an attorney, went to federal court, filed a lawsuit. And then at that point, you've got to decide if you want to turn it over to your insurance carrier, if you have coverage, or whether you want to pay an attorney out of pocket. And it's a tough call because your deductible is probably $10,000, $7,500, $5,000, and then your premium is going to go up next year. So,
are you seeing, what type of insurance are you seeing cover this? Because we have general liability, and that would have covered any particular fair housing claim minus after the deductible of $5,000 for us. but that could be, again, 75, 10, whoever the company is you're talking about. Are you seeing some insurance companies not even offer that?
I don't know. And I'm not a coverage specialist,
Okay.
But usually I tell the person, go to your agent, see if you have coverage. If they say you don't have coverage, I have a consultant we can use and take a look at and work with that and see if there is coverage. Mm-hmm. But typically under like the E&O, the errors and omissions part of that policy, there should be coverage, I would hope.
Yeah, you hope so.
You don't always get to select your counsel as well. But
that's another thing I'm not real happy with, but that's a side discussion for you and I. What I'd like to do is take a quick break. And prior to going on a break, I wanted to mention a couple other podcasts out there. Jordan Mula and Alex Osenenko are doing a podcast. Both of them have a great podcast show. And I want to give a quick little plug for that because I really like Jordan's show. I really like Alex's show. So be sure and go look for those and take a look at their PM Growth Summit that's coming up in February of 2018. I went to that particular conference this year, in 17. I thought it was a phenomenal deal. And we're definitely excited to get back to the PM Growth Summit. So visit them at the pmgrowthsummit.com where you can take a look at that conference and sign up. We'll be back in just a second. This episode of the Property Management Mastermind Show is sponsored by Mark Cunningham of Grace Property Management. Now, Mark has created some amazing products for property management companies. We have implemented his systems and his business income streams into our business here, and I can personally recommend them. If you're in the property management business, I encourage you to visit their website as you'll definitely find a product that will improve your business. I know Mark personally, and just a small investment to pick up one of his golden nuggets could earn you a return many times over. To learn more, go to propertymanagementsystem.org. Again, propertymanagementsystem.org. And to get a 10% discount on all of Mark's products, use the promo code BRAD, B-R-A-D. And we're back just from that quick break. Sorry about that. So what we wanted to catch up on now is we want to talk about fair housing. And we were talking about service animals. And prior to the break, we were diving into that story about the federal court thing, and that sounded just super expensive. So any advice there you would offer to the general property management population out there, the property management company owners, on how to handle some of those things?
As far as triage.
Well, you get into a fair housing situation or some sort of court battle. Let me just impose my will on you for a second. Settle at all costs.
Yeah. Well, it's better if you can dispose of the case at the investigation stage.
Okay.
So a lot of time, I would say 99% of these cases, once TWC or HUD says a finding of no cause, then the tenant goes away. They're trying to get their pound of flesh. They're done. They're not able themselves to successfully file a federal court case lawsuit. This isn't JP court, Justice Court for people down here in Texas. The small claims court. This is, big boy federal court with formal rules of procedure and pleadings. And they are just not able to do it. So they would actually have to go out and find a plaintiff's attorney to help them typically. Mm-hmm. And if I'm a plaintiff's attorney, I'm not going to take just any case because the insurance company, if you turn it over to insurance, could say, nope, we're tired of this, we're defending it. And then you spend all this time and they get zero. So unless they really do have a claim or the attorney feels they have a claim, it's going to die at the investigation stage.
Okay, good advice. Because the service animals and fair housing do kind of tie into each other a little bit, because the fair housing people that are investigating service animals are all kind of the same. Is that a fair assessment?
So the fair
the Texas Workforce Commission will be the ones investigating us for a fair housing claim. And that's also potentially where the service animals and all the other stuff would be going, right? It's all kind of the same umbrella.
I don't, as far as if there's a violation in a public accommodation, if someone's, I don't know who triages that. I've never defended a owner on a service dog ADA complaint.
Well, what if they just got an attorney and, come made your life miserable?
Yeah.
Then you would help us get out of that for sure. So let's talk about one thing, and I'm going to air some dirty laundry, so it's okay. Everyone likes to learn out there about other property managers. So knock on wood, we had our first ever fair housing claim just a few months ago, and you were able to help us with that. So without getting any sort of weird details, we went through the claim. Basically, we denied an applicant. The applicant went to fair housing and made some allegations, and you helped us respond to this. So one of the lessons learned is first bring it to an attorney, right? Don't try to respond yourself. And so talk me through how you would take a look at that case and make a response.
Sure. Well, the first thing that I ask for is I need to see all of your emails, your correspondence with this tenant, anything that was in writing.
Yeah, we did all the applications, emails, we got everything to you. Mm-hmm.
And then potentially have an interview with anyone that spoke with this tenant or the applicant and say, what did you say? What transpired? You know, are we going to get into a he said, she said, where they said, she said, the manager said something, you know, one of those deals. So we try to understand that. And the investigator is going to reach out and ask for our initial position statement. So at that point, we respond in writing with our initial position statement. And all through the process, they're going to ask you if you want to conciliate or make an offer. And usually at that point, we decline and we put our position statement out saying why, you know, my client's so great, they didn't do anything wrong, they're just trying to do the right thing, and why the person bringing the claim is out of line. And then at that point, they're going to look at that. Then they're going to make follow-up requests. They may actually come down and do an investigation on site. They may want to look through other files and things, and they have the subpoena power to do so. So it's better to just voluntarily produce what they're asking for.
Yeah, that's a scary thought. And we did make an offer to settle, but it turned out the fair housing folks just threw it out. What was the term they used?
Finding of no reasonable cause.
Yeah.
And they give you this long letter setting forth the different elements of the law and why the person didn't fulfill those requirements. And I'll be quite frank, you all did the right thing all the way through. I told you that from the onset. This case is bogus. There's no merit here. You've done the right thing, and I think they're just trying to take advantage of the situation. And that's exactly what I think the investigator saw.
Yeah, luckily we were able to get through that vindicated, which was a good thing. And the letter was 7 pages long. I mean, I'm reading it, I'm like, oh my God, I'm gonna go to sleep. But the worry for the management company owner is, at what point do you file a claim? So this is advice too. We got the fair housing claim in, and I immediately notified my insurance carrier, even though we never actually filed the claim. And so they were put on notice, they were paying attention, but they didn't have to pay anything out because it was under the deductible amount, just to have you represent us on that. So you wrote us a letter, you defended us. The letters you wrote were great. Point being is a couple lessons learned, and this is stuff you would know from anyway. Notify the insurance carrier and hire a good attorney to respond to that. Do not try and do it yourself, because I think there's going to be certain situations that, who knows? I mean, I could have said something wrong with the letter or not responded with a certain way. And when you got the case, this is where you want to get a good attorney. You're like, oh, I know this person, right? You told me that you knew the lady or something.
Investigator, yeah. I mean, you start dealing with them, and so I say, I won't give her name, but hey, Miss So-and-so, good to speak to you again. You know, it's been a while. And then, and I try to always go back to that relationship I have where they know that I'm trying to do the right thing. I'm trying to help. And hopefully they feel like I'm only representing scrupulous and good management companies.
Yep. And that helps because you remove the emotional side of it. Because I'd get fired up and start, dropping F-bombs and everything else. And you are just very calm and cool. And that's what people need to represent them. So you did a good job on that. I'm very excited to kind of be able to share the story and let everybody know we're vindicated. But also, there's certain things inside of that you want to make sure you're doing. Notify the insurance carrier and get a good attorney to defend you. So some of the fun topics we want to switch on to now, we talked about service animals and fair housing. I don't think there's ever going to be a hard and fast rule of how to exactly deal with service animals or with fair housing, other than having decent procedures and policies in place that will somewhat sort of try and map how you're supposed to act in those situations.
To triage the case properly. You need to triage it properly. You need to get it to someone that has the ability to make a decision based on some expertise. In this situation, a lot of situations, I have clients who just, every request they get, they email me. And if you have a relationship with an attorney that you can get a response from within 48 hours, it's, you email me, I'm going to get your response, and I'm going to even give you cut and paste this into a letter and send it back to them within 48 hours. And that way you're properly triaging it, you're nipping it in the bud, you're not letting this thing escalate out of control. And then the other part of that is have your staff do fair housing training. There's different programs, or there's a handful of attorneys that can come in, give you a program or give it to your local chapter, NARPM or what have you, and get fair housing training. Because when you do have an investigation, I'll go to the investigator and say, look, these folks, they're trying to do the right thing. They go to training every year, every 6 months, they send their staff. They've been to this training, that training, we document and show, or what you've done through Trek and different things. And then that does carry merit. They do consider that when the investigators are trying to look at whether you're trying to do the right thing. It does make a difference. That's
good. I think we're going to line up some training from you and get that documented. So one of the questions I thought of while we're talking about service animals, is there a no-brainer situation documentation that you would say, yes, approve them. For example, a doctor's note from a local doctor that we can verify, because we are allowed to verify. Am I not correct in that? If we get a doctor's note, we're allowed to call the doctor and at least verify that the doctor is real and their phone number is real and all that.
Yeah. So if you have reason to suspect otherwise, I would say it'd be okay to contact the doctor, right?
Okay. Because some people would ask about that. Are we allowed to even contact the doctor? Right? Because these are all questions that I've seen. Are we allowed to contact them, or are we even allowed to ask why they need a service animal, or we just need to verify that the doctor exists and is alive? Right. So those are things that we want to know. I guess there's no hard and fast rule to it, to where if it smells fishy, dig into it.
Right.
Is that a good rule?
Right. And in San Antonio, there are some pretty easy situations. People come from overseas duty, and we love to take care of our military folks, right? Hats off to them. And they come in and they've been through some really bad stuff in their lives. And it does benefit them to have an ESA. And they come in and say, I need an ESA. Here's my note. Here's what the dog does for me. Great. Just yesterday, I emailed a client. They said, what do we do? I said, granted, give it to them.
Yeah.
This is legit. The problem is that 90% of the cases, it seems like, are bogus and are making it hard for these 10% of the people who really need it to get it.
That's unfortunate. One of our challenges as property managers, we don't make that decision necessarily on behalf of the owner, because sometimes the owners will say, I don't want pets, no matter what, no pets, period. And we have to educate them. We have to indicate to them, you don't have a choice sometimes. If it's a service animal and it's legitimate and we verify it, then it's pretty much a done deal. If you don't do this, you're violating several federal authority acts. So that's where our education comes in, is getting it from good attorneys like yourself and then relaying that to the owners that we manage for, so they don't do something that could get them in trouble. Because this one case that we're talking about, you and I, where we had this fair housing issue. Well, they named the owners in the suit, in the file, the letter of the suit, whatever you call it. They named the owners of the home, not us. So we responded on behalf of the owners.
You as well.
Yeah, you as well.
And your individual.
And the individual.
In your company, they always name Brad Larson or whoever as well.
Oh, that's the part that really ticked off my staff, is one of my staff members was named, and that really just, I can't believe I was named. I'm like, well, that's how they roll. They name the owners, they name the management company, all the way down. Yeah. Scary stuff. All right, let's switch gears real quick and talk about a fun topic. Everyone, since you're an attorney, I'm going to give you a hard time. All my PM brethren out there, there's always a running joke that says, never rent to attorneys and never rent to realtors. And you've always joked back with me, well, they're not a protected class, so you could probably get away with that. But no one's going to stand up and say that, in reality. But I just thought I'd bring it up and we can kind of chat on it and see what you think.
Law students are the worst.
Isn't it?
Right? We've had this discussion recently.
We did, and I do want to talk about that.
Because they think they know everything about the law and they don't really know anything. And then they want to use that and flex their muscles. And And it can be
we just went through that, you and I. That's a good story to tell, because I think this is something that everybody could put into best practice as far as kind of how we handle this. Would you agree somewhat? Somewhat? You give me the blank stare, like, go okay, why not? Yeah. But what we did is...
I'll let you waive the attorney-client privilege.
Yes, we as a loose term on this, because it was us. Essentially, we got an application in from a brand new fledgling attorney who just passed law school. And this particular person wanted to make X, Y, and Z changes to our lease. And it was substantial. And basically things we couldn't or wouldn't want to change, right?
Right.
So essentially what we did is we went back to that particular applicant and said, if you want us to change this lease agreement, we're going to require a $1,000 retainer, because inside of that $1,000 retainer, I have to pay Robert Brown to analyze what you want us to do and make his recommendations to me, and potentially change our lease agreement, and potentially produce more documentation to even coincide with that lease agreement. So in that $250 an hour that you may charge, that's going to be eaten up in 4 hours. And so we counter proposed that back to the applicant, saying we're going to need a $1,000 retainer to do any of this, because you're lawyering up and intimidating the heck out of us with your lawyer speak. I have to go seek my attorney to counter your lawyer speak and go back to you. And that particular applicant said, I'm not going to do that. And they went away.
Just give them their money back.
We gave them their security, their application back, because we said, this isn't the situation for you. That's fine. We paid them their application fee back, and they went on their merry way to go harass some other owners. But that would be one technique that I would not necessarily recommend. I'm just telling the story.
Or you could tell them we're not changing our lease form, because you can't alter your operations by having 700 different leases out there. You've got to have certainty that you know what this lease says.
That brings up the other point, is we could have just taken the hard and flat, no, we're not doing anything, not changing our lease. But then they would have rented the home potentially.
And then you
would have had issues down the road, getting constant lawsuits.
And a funny personal story, when I was a second or going to my third year of law school, I went to sign a lease with this really kind of nasty place to live as cheaply as I could and try to get through law school. And I went into the management office and they printed the lease out and I started making revisions to it. And the leasing agent took it and she just stuck it in the shredder. She's like, "You can't do that." It's like, "That's not permitted. My company will allow you to do that." And I said, "Okay." So I just signed the lease. But anyway, and it worked out fine. But
that happens more than you know. I think every property manager out there would say they've sent lease agreements to attorneys and they get it back all marked up and they just shake their head and laugh and put it in the shredder and say, this is it. It's either this lease or nothing. It's just the worrisome side of what happens when, who knows what down the road, security deposits and all that. So last thing we want to talk about, because we can spend a lot of time talking about this if we really wanted, is dealing with some negative online reviews. And so I'll tell kind of people what we do, and may not be the best practice but basically it's kind of what we do, take it or leave it. So we do like to carry a non-disparagement clause inside of our lease agreements and our management agreements and our applications. Now, the non-disparagement clause as an enforceable document or enforceable paragraph is debatable. And I'm not recommending anybody do this, but this is what we do have made a business decision on. And this was prior to this law being passed. Are you familiar with that law?
Yeah, and I thought I printed it out, but I don't have it with me. The Consumer Freedom Response Review Act?
Yeah, some CFRA Act. Basically, it says consumers have the right to talk trash about anybody they want online. So that means I can go online and tell everybody you're a Martian or you're an arsonist or something weird, and nothing can become...
Well, they can't engage in defamation.
That's where I'm going. Okay, that's where I want you to jump in and say... All right, Brad, stop talking and let me tell you what's really up. Go ahead.
Sure. Well, this act was passed, and I understand it to be meant toward these big companies where, let's say I'm going to buy this software on the computer, and I go to click a button and there's all this stuff. Do any of us read it? No, I'm a lawyer. I don't read it because I don't have 2 hours to sit there and read 8-point font. And so we click OK. Well, let's say in that paragraph or in that 20 pages of 8-point font, it says something about I cannot post negative reviews and blah, blah, blah. And if I do, I owe them a liquidated damages of $1,500 or $15,000 or whatever. And so this law says that's not legal. We got to let people talk openly and freely about services. They can't be held hostage by big bank or big company and basically be intimidated into not posting negative reviews. Where that spills over in this realm is the law is... I believe it's limited to I think it's the sale, and I wish I had it in front of me, but it's the sale and leasing of goods and services. Okay. And that's a consumer-based transaction. You're buying a pencil or you're leasing a car, a good, or a service, not real property. The law does not say the sale or lease of real property or real estate or property. So I think if we technically and strictly read the statutes in the four corners we talked about earlier, if you read the statute for what it is and the intent of the legislator, it would not apply in the landlord-tenant context. And it certainly wouldn't apply for sure with your negotiations with your property owners. And if you have a non-disparagement in your property management agreement. However, that is a brand new law. There's really not much case law out there. So that point has yet to be settled in the courts as to how far does the sale or lease of goods and services go.
Yeah, that's a scary thought because typically what we're doing is if we do get a negative review, oftentimes it's from an outgoing tenant. And the outgoing tenant they're scorned, they're mad, they're out of some money, and they'll say nasty things about you. You know, you guys are criminals and all kinds of stuff that you and I have seen. And if the Yelp or Google or whomever doesn't remove that review, it sticks there. And it can be infuriating to us because they can say whatever they want.
Not just infuriating, damaging it.
Very damaging.
It can derail your business, all that you worked hard to build.
Yeah. So let's talk about that. So outside of that whole non-disparagement clause, let's say you don't have one, or let's say you choose not to use one. What would be your advice if you get a really bad review and they're basically accusing you of doing all kinds of crazy things? What are your options?
Brad Larson's a thief, a crook, a money launderer, whatever. He does all kinds of illicit things. Well, I think the first thing you do is go to the Yelp or whatever service provider and say, this is not true. This is, they're defaming me. They're defaming me.
Assuming they blow you off, because that happens. I mean, even if you get a bad review, you try to go in there and say, this is not me or whatever. Yelp gives you the options to do, and Google does sometimes as well. Assume they are going to blow you off because they always do. They don't care what you say.
We probably should start writing demand letters to them and suing them in JP court, making them come down to Bexar County.
I would love
JP court. But
Yelp is the scorn of all management companies, and I'll be the first to tell you that.
Right. Well, then your next step, of course, you can respond to it, right? And I would encourage people to respond professionally and refute what they're saying without revealing confidential information about that tenant.
Don't name drop or anything like that.
Right. Okay. Or they can be reached at this phone number. Here's their address, or their social security number is blank. Of course, you're not going to do that kind of stuff. So you'd want to respond right away to the review, because as a consumer, when I'm looking at reviews, I know that people are going to give bad reviews. But when the owner comes back and says, I'm sorry you felt that way, please contact me to discuss this, or we've tried to reach you, blah, 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 then you feel better about that, right? When you're reading the reviews. Certainly you can send that tenant a demand letter for defamation.
Okay.
Or I guess you could try to, if there was a non-disparagement clause, you could potentially try to enforce that. But you'd then be relying upon the legal opinion that the Consumer Freedom Review Act does not cover.
That clause that we do carry, it does go both ways. So that's one thing we do tell owners and tenants, say, look, this is a two-way clause. We don't want you to talk trash about us on Google, and we won't talk trash about you in the same regards. I won't start a website that says thistenantsucks.com and just go on there and start putting all their videos on there. I could really go over the top of some of this stuff, but it's a two-way street. That's one of the things that's reciprocal that I would think it's not as much so for the big banks. You're talking about somebody signing a form and they click a box and there's 40 pages of 8-font stuff. That's not necessarily reciprocal, right? Inside of there. Right. But our agreement is. And so that you could argue that, yes, it's reciprocal. We want you to remove your review, and here's why. There's liquid damages. But in reality, common sense practice, we're not going to go sue anybody, over that stuff. I mean, we can. And if it was really something that we were super upset about, we could. But talk to me about filing a suit. You got to hire Robert Brown, go to file a suit.
Well, you could do it in JP court yourself.
But why? It's just clown court. You don't want to go there. We want to go to big boy court. So we want to go to the local county court.
Or district court.
And there's filing fees.
Yeah, with service of process, maybe up to $380.
Yeah, so
$80.
Filing fees, your fees. So you're into it for $1,000 just to even go to court. And a lot of times,
assuming you can find them.
Assuming you can
maybe
find
they're out of state now, and then you're going to have to try to serve them out of state, and it's a hassle.
It is. So I would not say this is the best practice, but sometimes it's smarter to reach out to them and potentially offer them a little bit. That's a technique I think that would be well advised for some folks.
They have little to gain by leaving a negative review, but you have a lot to lose.
Correct.
And so if I'm them and you come and said, I'll give you a token settlement, go out to dinner with your wife. Okay. I feel like it was a small victory for me. I feel like I got my little win that I needed to get, and maybe it's a win-win. And you get rid of the defamatory comment, and they get to go have dinner with their wife. I don't know.
Yeah, that's a good practice, I think. Find a win-win. If they're willing to take, a small amount, you get a settlement signed, like go to your attorney and have them draft up a settlement. You probably have draft templated settlements that you can pull up really quick. You get them to sign it, send them the check. They remove the review, or the review's been removed by that point, and away we go. We move on with our lives. That's rewarding bad behavior, and I hate it, but what choice do we have sometimes? That's the world we live in. What do you think?
Yeah, I mean, managing your online reviews is critical to your business. I mean, we all look at it. If you're going to go hire someone to clean your carpets, for example, or you're going to go look for a gym class for your kids, you're going to look at the online reviews. And if this person's got 3 stars, you're probably going to say, but if they've got 4.5 or 4.9 on Google, you feel better about it. Same thing with you. So,
and Google ranks that now. on order of preference, a lot of times in the pins, they're going to rank that by how high your reviews are. And then, of course, Yelp, you're going to have other ways that will highlight how good you are or bad you are in your reviews. So it's very, very important right now for the management industry. A lot of property managers out there are paying a lot of attention to this. So this could be one technique they could or should employ, is we do use that non-disparagement clause. And if we do get a negative review, we can go to Robert and ask him to send out a nice letter, which would say something to the effect of, please contact us. You have this review. We want you to remove it. But what it does is it starts dialogue between a neutral third party, Robert, and that superheated tenant, for example. And there's an opportunity there for kind of like the happy ground to be met. Am I right?
Yeah, except I'm not a neutral third party.
Well,
I'm your advocate. But
you're an advocate, but you are way less emotional than me.
Right.
Because when they get on there and say, Brad Larson, is this, oh, I'm fired up. It's go time.
Yeah. And we can play good cop, bad cop. Look, I understand you're upset. I understand that, you feel this way, but let's take a step back and look at this. There is this agreement that does say this. You have potential liability. He's, maybe even willing to offer, put something on a table just so you can walk away amicably and everyone goes away and, friends. Well, not friends, but
at least, part way is different. Yeah. Better than them, hating us on online and then they turn into the internet terrorists. That's even worse sometimes.
Post 5 reviews and
everywhere they go.
Yeah.
Yeah. They go out and do 5 reviews and it gets to the point where, maybe a little bit of a settlement would have really helped. All right, Robert, this has been a great opportunity for us to talk with you. I really appreciate your time. A lot of insight on service animals, fair housing, and it's been really enlightening to have you on the episode here. So any last minute comments you'd like to make? How do we reach you, by the way?
Just call my office.
Okay.
210-782-9111. Set up a time to talk and I'll be glad to, talk with you and see if there's anything I can do to help you all.
I think some of the advice you've offered us can translate to any market, because someone may reach out to you and ask, well, what about my policies and procedures? Can you review my policies to see if I'm compliant with fair housing? So that could be an opportunity for you to work with anyone.
I even have a sample template here that that I've drafted that I feel is a good way this is for the back. We didn't even get into the disparate impact and the background screening. Maybe that's for another podcast.
Oh yeah, because we could be talking about that for another hour.
Criminal history and look back periods and different things. So, I've got all kinds of forms and things that I'm happy to share with clients and help them to stay compliant and minimize their risk.
Awesome. Really appreciate your time again. Thanks, Robert.
Thanks, Brad.
Today's show has been sponsored by Virtually Incredible, providing tenant screening services, call center services, and video production services to property managers. You may also visit them at virtuallyincredible.com.
This has been a podcast episode by PropertyManagementProductions.com. Be sure to subscribe to our podcast, leave us feedback, and come back for our next episode.